attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the final in a LawCast series talking about Regulation A. Exchange Act Section 12G requires that an issuer with total assets exceeding $10 million and a class of equity securities held of record by either 2,000 persons or 500 persons who are not accredited register with the SEC, generally on Form 10, and thereafter be subject to the reporting requirements of the Exchange Act. Regulation A exempts securities in a Tier 2 offering from the Section 12G registration requirements if the company meets all of the following conditions. The company utilizes an SEC-registered transfer agent. The company remains subject to the Tier 2 reporting obligations. The company is current in its Tier 2 reporting obligations, including the filing of any annual and semi-annual report, and the company has a public float of less than $75 million as of the last day of its most recently completed semi-annual period, or if no public float, had annual revenues of less than $50 million as of its most recently completed fiscal year end. Moreover, even if a Tier 2 issuer is not eligible for the Section 12G registration exemption, that issuer will have a 2-year transition period prior to being required to register under the Exchange Act, as long as during that 2-year period, the company continues to file all of its ongoing Regulation A reports in a timely manner with the SEC. As I've touched on in this LawCast series, Tier 1 offerings do not preempt state law and remain subject to state blue sky qualification. This process is expensive and time-consuming. The NASAA offers a coordinated review program which can be helpful, but a company must still comply with each state's differing requirements and interpretations. Tier 2 offerings are not subject to state blue sky law or state review or qualification, i.e. state law is preempted. State securities registration and exemption requirements are only preempted as to the Tier 2 offering and securities purchased pursuant to the qualified Tier 2 for a 1A offering circular. Subsequent resales of these securities are not preempted. Also, preemption does not extend to the broker-dealer registration requirements. 5 states do not have an issuer broker-dealer exemption for public offerings, such as a Regulation A offering. Those states are Florida, Texas, Arizona, New York, and North Dakota. Also, Alabama and Nevada require that officers and directors that sell securities on behalf of the company register as an agent. Both Tier 1 and Tier 2 offerings remain subject to state anti-fraud provisions, and states may require certain notice filings. In addition, states maintain the authority to investigate and prosecute fraudulent securities transactions. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.